Hi, thank you for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Mark Cobb, a Georgia construction lien law guru. Today's webinar topic is what happens after I record my lien? How do I get paid? So without further ado, I would like to introduce the wonderful Mark Cobb.
Wow, thank you, Jesse. I appreciate it very much. I love SunRay. First of all, y'all do great business, but I also love y'all because y'all challenge me. You give these fantastic topics, and then I have to condense it down in a very short time. So we're going to move quickly today. We've got a lot of things to cover, but we'll take questions at the end. Just remember when you submit questions, don't use company names. Just kind of make them very general, and we appreciate that. So with further ado, let's get started. So we're gonna cover real quickly. I get these questions a lot. What do I do? I filed my lien, now what do I do? And so I wanted to walk you through it from my perspective as a lawyer. What we do, we assess the claim, we look at contract rights, then we help review the business decision versus the legal decision, and then we decide whether or not, what action steps we're going to take. So today we're gonna talk about what happens after I record my lien and how do I get paid. So when I get a phone call, I have a series of questions I want to ask clients, and I picked the top 4 here that I want to discuss with you. The very first question I have is what date was the lien filed? Because I need to know the deadlines. It is amazing. Sometimes clients call me the day of the deadline, critical, don't ever do that to anybody. Other times we may have almost a year before we're forced to do something. So that's the most important part I want to know. So in order to perfect a lien in Georgia, and that means take it to the next step, you have 2 potential deadlines. The first one is within 1 year from the date that the lien was filed. If an owner or general contractor files a document called a notice of contest of lien, then that 1-year deadline is reduced to 60 days from the date that the notice of contest of lien was filed. So when I get a phone call, I need to know, do I have 60 days, 45 days, 30 days, or do I have like 200, 300 days? Because that changes the client's options. Another important question I'm going to ask is, what does your contract say is the next step for perfecting a lien? So in Georgia, that deadline we just discussed, in order to meet the deadline, you must, quote, commence an action. That's the legal words that are used. And there's several ways to commence an action. If bankruptcy has a way of commencing an action. If a contractor has absconded, left the state, there's a way to commence an action. But for virtually all cases, 90% of the time, 95% of the time, maybe even 99% of the time, there's 2 ways to commence an action. It's either by filing a lawsuit against the entity that the lien claimant has a contract with, or if the contract mandates binding arbitration, in that case, in lieu of litigation, you would make a demand for arbitration. Again, I want to know that up front because that's going to impact your cost. It's going to impact your timetable for when you get paid. It's an important consideration. The third question I'm going to have is, I want to know other deadlines. What else have you done to perfect? What else have you done besides the lien? The lien is just one legal theory that helps you get paid, but your contract will also help you get paid. If there's a potential for payment bond claim, that will help you get paid. If you have a personal guarantee, that will help you get paid, and each of those have their own deadlines. Generally speaking, a payment bond claim and a lien are more likely to be the shorter deadlines, but not always. So we need to review those deadlines as well. And then finally, the question is, from a practical standpoint, how much money is owed? And it can be the lien amount. More often than not, it is. But frequently, there are additional amounts, particularly when you look at suppliers. Maybe they filed a lien on one project, but that same customer has multiple other projects that are still pending. Maybe liens haven't been filed. Maybe lien deadlines were missed. But at this point, I want to know, okay, let's perfect the lien. Maybe the lien is $40,000, but maybe he owes another $60,000. So looking at a $100,000 debt versus the lien amount for $40,000. Again, changes our options, changes the things that we might consider doing. I mentioned one of the questions is, let's talk about what the contract says. And that is so important It's the governing document. So before we take the next step, we are going to want to review the contract. And there are things that each of you hopefully have successfully done. First question I'm going to ask is there a signed contract? And if so, I want a copy of the signed contract. I've been doing construction law for 25 years. I am still amazed, flabbergasted, I don't even know what word to use, amazed at how many people do not have a copy of a signed document. They'll hand me a document. They say, well, we sent this to them. We signed it. But what I really, really want to see in a perfect world is a mutually signed contract signed by all parties. When I'm looking through the contract should have a default provision. What happens in the event of default? And non-payment is one act of default usually. And I want to see what notice requirements were required by the contract. I'm going to ask my client, did you meet those notice requirements? If it says you have to give them notice within 10 days, did you give notice within 10 days? Did you give them an opportunity to cure it? Those factors can matter as to the collectability of the debt. As I mentioned before, I'm going to look at your contract to see if it requires binding arbitration. Frequently in construction contracts, it does require binding arbitration, but it doesn't always. Sometimes it allows arbitration as an option. Other times it says your rights must be enforced by filing a lawsuit. Either way, that's important information for us to help assess your claim and help you get paid. I would like to make a note that under the general rules of arbitration published by AAA, American Arbitration Association, for certain construction matters, most of them in fact, it does require mediation prior to binding arbitration. That won't affect, it does not affect your deadline or your ability to make a claim to go into arbitration, but mediation is something that is frequently required. And mediation is a much less expensive, much easier, much faster way to collect money. So I love seeing that in a contract, particularly if it requires mediation specifically in the contract. Another big factor in assessing someone's claim and giving advice what to do after you file your lien, I want to know what your contract says about venue. So venue is where you would bring that arbitration or where you'd file a lawsuit. If you are a subcontractor and the general contractor has given you its standards subcontract agreement, probably the venue is going to be someplace convenient to the general contractor. It may not be convenient for you. To give you one example, we handled one recently. It was a project, a mall in California. There was the subcontractor was from Georgia. The general contractor was in Illinois. Guess where we had to file suit? Actually, this particular case was arbitration. We had to file suit in Illinois, or to make demand for arbitration in Illinois. So that contract provision is very important. So for those of you who are able to produce your own contract, particularly suppliers, material men, great position to say, here are terms and conditions, sign it. In that case, you want to make a venue convenient for you and or possibly your attorney. So it lowers your cost, inconvenience, and impact on man hours as in case you have to bring witnesses, those types of things. Another important component is which state law applies. That can be a very important situation. In this case I just mentioned, where the subcontractor was in Georgia and the GC was in Illinois and the project was in California, the contract specified that California law applied. It meant we, as Georgia attorneys, had to bring in a consult from California. Did a great job. We actually won the case for our clients, but the point was it did increase the cost to our client. So what state law applies can affect what you're looking for in terms of your plan going forward. And one of the biggest things, if you have the ability to negotiate something in a contract, is does your contract include attorney's fees and cost to collect? That's probably the single first question I get from a client. And all I can say is it depends. Generally speaking, in America, each party pays for its own attorney's fees and cost. However, that can be shifted by contract. And it can also be shifted under other circumstances if there's if you can prove that truly the litigation has been frivolous, and that can be difficult to prove. The difficulty with both these provisions, the contract provision and a frivolous litigation claim, is that it's still very much judge dependent. We are seeing a trend for judges awarding more and more attorney's fees, but to get the full amount is still difficult to do. But if it's in your contract, you're much more likely to get your attorney's fees, and you definitely, well, not definitely, but more likely to get at least a portion of your fees and costs collected. So those are some of the legal considerations, but each of you run a business, and the sole purpose of that business is to make a profit. You want your money, you're owed your money, you provided the work, you provide the materials, you're owed that money. However, litigation, arbitration, really any legal proceeding can get very expensive. So you want to begin from your end considering what these costs actually are. In the early stages, it's very difficult to predict. Part of it is, why aren't you being paid? That's usually my question. Do you have any reason? Is it slow pay for the top up? Has the lender stopped lending money to the owner? Has the owner stopped paying the GC? Do the GC and sub have a fault problem, and therefore they're not paying you as the supplier? Those are very important facts to know that help begin assessing that. It still determines upon the integrity of the other parties, their goals, the financial abilities that they have to pay, lots of other things. But in addition to the hard cost, you need to begin assessing the soft costs. What does this mean to you as a business? If you're a small mom and pop business, it could take man hours in order to get all the documents that you'll have to produce, daily logs, pay apps, backup for pay apps, labor schedules, time to be a witness, time to talk to attorneys, time to show for court. Those are soft costs. And then there's always just the general cost of stress. And it can be difficult and a hassle. So those are things that need to be considered when you're looking at whether or not to move forward with your lien. I alluded to this earlier, but it's very important at this stage to know what other options there are for collections, because under straight lien law, you probably are not going to get attorney's fees and cost. But if your contract says that, then you're much more likely to get attorney's fees and cost. Similarly, if you have a personal guarantee, that makes me very happy. And really, if you're a supplier or materialman, there's really no reason why you shouldn't get a personal guarantee for most of your customers. I have seen them on subcontracts. I've included them in subcontracts. We've even done it. There's even a case where it was done subtly. We sort of copied this sometimes, but on a subcontract, there was a provision that said whoever signs this is a personal guarantor. I mean, there was it wasn't hidden. There was a bold heading, and it was underlined, and it was very clear. The court found it was very clear. So therefore, the intent was whoever signed that document had a personal guarantee to the subcontractor. Guess what? That helped them get paid. Most people are familiar with payment bond claims on municipal or state projects, and that's true. We do those instead of liens on municipal and state projects. However, increasingly, private projects also have a payment bond claim, and there's no reason why you cannot file your lien and make your payment bond claim. If you have a simultaneous one, that's great. So suddenly, for most of our suppliers, it's great, because not only do they come to me and say, hey, Mark, I've got a lien, but they say, Mark, I've got a lien and I've got a payment bond claim. So now I've got the owner responsible for the lien. I have a surety responsible through the payment bond claim. And then I say, well, do you have a personal guarantee? And they go, well, actually, we do have a personal guarantee too. So now we're looking at 4 potential payees of that debt. You're looking at the actual customer or client of yours. You're looking at the owner through the lien. You're looking at the surety, the insurance company through the payment bond claim. And now you're looking at an individual person who owns your client is also likely to pay. And so you've got 4 pockets to go after, and that increases the odds of recovery significantly. Another consideration is collections. Do some due diligence. Of course, you should have done due diligence at the very beginning before you signed your contract or shipped materials. However, it's not too late now. Due diligence now can even help you begin assessing the likelihood of recovery and the collectability. Do they have other projects? Do they have other problem projects? Or have other people filed liens against them? any newspaper reports, if someone as a principal of the business died, those sorts of things can help you understand the likelihood of a recovery. Again, contract rights. We just hit on a few on the screen before, but there are so many parts of the contract that can be beneficial to you that if you haven't reviewed your contract in 2 or 3 years, 4 years max, you really need to sit down with that contract and make sure it meets your needs and that it effectively protects your rights. But also customer relationship is important. I mean, there are customers who value their relationship with you and they want to keep you happy. GCs do that for certain subs, absolutely. Customers use that with their supply houses, absolutely. So that can impact your right to recovery. Also, there's a flip side to it. We've had several clients who may have filed a lien or may have taken the first step, but they value the relationship on a national level much more so than, say, on a local level where there's one project that went upside down. And so you have to weigh that consideration too when you're looking at your legal rights from a business decision. So hopefully you've recovered, you reviewed your legal rights, you reviewed your business rights. Now you have a decision to make. What do I do? How do I get paid? Well, the first one may not answer the question fully, but it's true. Do nothing and hope something happens. So remember, you have that deadline. Generally, the deadline is 1 year from the date that the lien was filed. You have a year to negotiate. You have a year to just wait to see if property is sold. And if that property is sold, the closing attorney is going to contact you as lien claimant and say, hey, we're trying to sell this property. You filed a lien. We need to get the lien removed. How much do we owe you? It does happen. And certainly the do nothing is something we, hate to say this, but we have to advise when the value just isn't there. I mean, this morning, but as preparing this seminar, I had a prospective client contact me with a $1,300 lien. We're going to treat that much differently than a $250,000 lien. That's just the reality of it. I alluded to the second step, attempt negotiation. I mean, you have up to a year. You can be using the lien as a threat. You can also use the lien to get upstream. So if you're a supplier, you've been sending demand letters to your subcontractor, you can also send letters to the general contractor, or phone calls, or however you want to reach out to them, emails. Same thing with the owner and say, hey, we filed a lien. What's happening? Why aren't we being paid? What are you doing to help us get paid? One classic thing you can ask for is a joint check. Say, hey, we're not being paid. Can you joint check us? Or in lieu of that, can you just pay us directly? Particularly if there's retainage on the project, there's a real good chance that somebody higher up will use that retainage to pay you to remove the lien. Another option, of course, is to bring a lawsuit, or if required, make a demand for binding arbitration. It's definitely, something you need to consider doing. There's no magic numbers. Every business has its own concept. I will say that in Georgia, small claims court is $15,000 and lower. So for those types of claims, the client can handle them themselves. You can file your own complaint, show up for court, do a little Judge Judy or Perry Mason, depending on your what you want to do, and hopefully prevail and win the lawsuit. But put that in context, that $15,000 small claims, it has been $15,000 since I've been practicing law in Georgia in the 1990s. So it really is a very, very low threshold amount. We tend to say, maybe at 50, 75,000, you begin seriously considering a full press, you begin considering some sort of litigation, but your goal for anything under 100,000, in my opinion, is maybe you file suit to perfect the lien, but you really want to get mediation. You really want to stick with negotiation. You want to get a substantial amount of your payment, but maybe not all of it. Certainly the larger the claim, then the higher amount you want to pursue and more aggressively want to pursue. One important note is if you do bring a lawsuit or make a demand for binding arbitration, then in order to fully perfect the lien, remember, to perfect the lien, it's actually 2 steps. You have to bring the lawsuit or make the demand for binding arbitration. Then 30 days from the date you bring lawsuit, or 30 days from the date you make the demand for binding arbitration, then you must file a document called a notice of filing of action to enforce a lien. That has to be done within 30 days. You probably want an attorney to do it, but you need to, it has to reference the vesting deed for the property owner. It has to tie the original lien in with this lawsuit or arbitration matter, but it's something you want to do. If you don't do that, then your lien will expire. And then another thing too is, and we talk about this too, is you can waive your lien rights. Again, having a lien is one legal theory for recovery. You may have that deadline. Maybe they file a notice of contest of lien. You've got 60 days. You're thinking, well, the owner's going to pay me, or there's some circumstances there, and you decide for good reason you're going to waive your lien rights, but you still have a contract claim if you don't get payment. Maybe there's something else you can do. Maybe there's a side agreement. Maybe you can go and enter into a settlement agreement with the GC or the owner or someone upstream. That can all be, there's lots of options that you can have. Just be creative about it. One thing we always look at that's kind of creative is we do look to see if there are any permits pooled, if there are any pending ongoing projects for somebody. That tells me there's money. And that tells me it might be there's money coming into that business. And if the timing's right, we might be able to get a judgment against them and then garnish their wages on another project. We've done that successfully a handful of times. And the contractor's always like, whoa, where'd this garnishment come from? And why are you garnishing me? Well, you stepped us on this other job, so we're coming after you on a new job. So use everything at your disposal. Use your contract, use your business skills, use creativity. Each of these slides could have been an hour-long seminar. In fact, we pretty much do one for each of those, but I wanted to hit the very topics, hit the very 40,000 view foot of these topics for each of you. And I hope that each of you has some questions. You're welcome to ask away now if you'd like.
Well, thank you so much, Mark. You really did go over a lot of the nitty-gritty of what we need to include and pay attention of our contract, so I appreciate that. There is a question that has come in so far. Please, if you guys have any other questions, go ahead and ask it in the questions or the chat section so we can get those addressed for you. This question says, can I collect the entire unpaid amount from the property owner if they have already paid the general contractor in full?
Yeah. That's going to take separate assessment, but generally speaking, you can pursue the owner for the value of the amount of work or services or materials that you supplied. The owner does have some defenses, and it kind of goes to there's several things, but one of the big things it goes to is called an affidavit of non-payment. Excuse me, an affidavit, the time of closing, and the way to thwart that is to file something called a preliminary lien, which is another document you can do at the front end when you begin representing somebody. We tend to say that preliminary liens in Georgia are useful when there's high credit risk or a large amount. We tend to do those at six-figure debt or higher. But yeah, the owner is potentially responsible for the amount of the claim of lien.
Okay, perfect. Thank you. And then this one, I think you've already touched on it within the presentation, but I'll go ahead and ask it for them as well.
Sure.
Is a written contract required to file a mechanic's lien in Georgia?
It is not. It is not. Now, we want to see one. It's going to help your rights. It's going to help establish your rights and helps it helps clear up who your customer is. That's one thing we see a lot. That's one reason why I want to see a signed contract is was so many, particularly in real estate, so many businesses have multiple entities. So it might be, ABC Electric, could be ABC LLC, could be ABC Inc. We need to know exactly whose name it is, and contracts help spell that out.
Yes, very, very important. So it's not totally required to do it, but it's always best practice to have your written contract. So get your contracts in order and get them signed. All right.
Mm-hmm.
I think that's all the questions that have come through right now. If anyone does think of a question that wasn't addressed, please feel free to reach out and we'll be sure to answer any other questions for you. Please go to the next slide, please. All right, it's pop quiz time. We're testing your knowledge. Take a look at these questions. If you feel like you understand and know the answer to them, please answer in our chat and we will send you guys out a little gift for you. The first question, as a subcontractor or supplier, when should I file a notice to contractor? And then the other question, when should I send my Georgia claim of lien? So please go ahead and type your responses in there so we can get you guys sent over a gift. I know you guys know this. I know that Mark has gone over it. So pay attention, answer in. We'd love to be able to send you guys out a little something. All right, please go to the next slide for me. Wonderful. All right, so here are some more of SunRay's resources to help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources and so much more. There's deadline calculators, project information sheets, etc. So lots of stuff on there to help get you guys organized and make sure that you guys are getting paid. All right, go to the next slide for me, please. All right, we have a collection site of SunRay now. So if you are in need, please check us out. You can go to sunraycollections.com. You can send us an email, give us a call, and we will explain what we can do to help get you guys your money. Next slide, please. All right, so the next webinar with Mark, we have how to get the bonding company to pay. That's going to be August 12th. And then the one after that is don't sign a release unless it says this one thing. That's October 2nd. So go ahead and register for free at sunraynotice.com/education. And go ahead to the next slide for me, please, Mark. It didn't have the slide in there. I'll go ahead and I'll talk about it though. So if you are in the Atlanta area, Mark is actually going to be presenting alongside of SunRay for a live seminar on August 23rd. So check it out. You can go to sunraynotice.com/seminar and get registered for that. It's going to be how to get paid faster with liens, bonds, and contracts. So please, we'd love to be able to see you guys there. So if you're in that Atlanta area or you're willing to travel to view us, you can always come on over there and we will get you taken care of, answer questions, you'll learn a little bit, get to network, it's wonderful. All right, so on this slide, if you don't mind, take a moment to give us a little bit of a review on Google, scan that QR code for us, we would really appreciate it. It takes about a minute of your time, helps get the information out there to other contractors like yourselves, and we really do appreciate that feedback. All right, go to the next slide for me if you will, Mark. All right, and with that, that is all we have for you guys. We hope you have a wonderful day. Thank you again, Mark, for giving that presentation. Thank you for everybody who was able to attend. We hope to see you guys at our next webinar. Thanks again, and have a wonderful sunny day. Thanks, Mark. Thanks, everyone.
Thank you.